happy to be here for the afternoon docket of our June session here in Middle Tennessee. Any preliminary matters?
No, Your Honor.
All right, if you'll call our next case, please.
State of Tennessee versus Sedrick, Darnell, Cummings.
Good afternoon, Your Honors. Drew Justice for the appellant, Sedrick Cummings. I'll reserve 4 minutes. There was no probable cause to support the search in this case because the 3 grounds the trial judge used to sustain probable cause were all basically just too vague and or unsubstantiated. Now, the main fight we had at the trial court level was over a 4th ground, and that was specifically whether the police had the right to go up to the back door where they did get a direct, strong smell that the smell of either hemp or marijuana was coming from the house. However, we won on that issue, and the judge found that the police did not have any grounds to gather that evidence. So ultimately, he excised that 4th ground from the affidavit, and then he decided probable cause based on the other 3 points of evidence. I will say it's a little bit debatable whether either that 4th ground we were fighting over even really mattered, because after that hearing and after that ruling, the Tennessee Supreme Court ruled in State versus Green. As far as I can tell, they ruled that the smell of hemp or marijuana by itself does not even give probable cause to search without more. But regardless of whether that was important, the judge excised that, and so we don't have to worry about that anymore. And now the question basically for this court is, did the police, I mean, it seemed like they were basing their warrant primarily on that, but now the question is, did the police nonetheless do such a good job investigating this case and in drafting this affidavit and warrant to where even after their main piece of evidence is knocked out, there's still probable cause? Ultimately, all that's left once we excised that 4th ground was 3 points. One, an anonymous tip. Specifically, it was a tip that Cummings at his residence was storing drugs. However, the tip never specifically said what that residence was or what the address was, and the police said that they knew that the address belonged to him, but they never said how, never gave any source of knowledge. 2, the second point was that the police, when they pulled into the driveway, they could just vaguely or in some way smell hemp or marijuana in the air without specifying where it came from. And then 3, they had some evidence that 20 years ago he had been convicted of selling marijuana. And it is our contention that those 3 remaining points are not sufficient for probable cause. Now, to start, we have the anonymous tip. The main cases that I've relied on here actually don't even deal with probable cause. They deal with reasonable suspicion. And so what that means is if I'm right in citing those 2 federal Supreme Court cases, then not only was the affidavit lacking in probable cause, but it didn't even have reasonable suspicion to support any further kind of investigation. The first case that I've really focused on is Alabama versus White, and there the Supreme Court talked about how an anonymous tip can sometimes give grounds for reasonable suspicion. But the main test they look at, the key issue, is whether the anonymous tip seems to have insider information. Can that anonymous informant make predictions that are shown to be accurate? And in Alabama versus White, the police got a tip that a lady was going to be trafficking drugs. The informant said that she would be leaving her house around a certain time, carrying drugs with her, and going to a certain location. The police scoped out her house. They observed her get in the car. They followed her. They didn't follow her exactly all the way to the location, but most of the way to the location, and she seemed to be going to where the informant had said she would be going. And ultimately, the Supreme Court said that, in essence, they appeared to say that that wasn't good enough for probable cause, but they said reasonable suspicion is a lesser standard than probable cause, and that anonymous tip was good enough to give reasonable suspicion to stop the lady for a traffic stop. And then once the police stopped the lady, they then interrogated her and got consent, and that was their probable cause. Their consent was their grounds to actually find the drugs and arrest her. But they focused on the fact that the informant was able to make those predictions, thereby showing reasonable knowledge, not just public information. Now, on the flip side, we had Florida versus JL, and there the Supreme Court said that there was no reasonable suspicion to search a youth for a gun merely because an anonymous informant had claimed that the youth had a gun. And the Supreme Court focused on the fact that there was no prediction, there was no apparent insider knowledge. All the informant had was public information, namely that there was a youth standing there who fit that description. And so they said that there was no reasonable suspicion to search the suspect in that case. Here what we had was an anonymous tip who said Cummings had drugs in his house. However, the informant didn't say where the house was,
They
nor...
also had guns, didn't they?
Yes, Your Honor, guns and drugs in his house.
So that's not something someone walking down the sidewalk smelling marijuana would necessarily know as to the firearms.
I suppose not, Your Honor, but what I'm saying is that would be analogous to the exact accusation made in Florida versus JL, where the person claimed that the person had a gun on him, but yet the Supreme Court said, like, I guess it's a claim of insider knowledge, but it's not verified. It's not a prediction that's been shown to be accurate.
Sure, and you see the danger that could occur if JL went the other way, that any anonymous tipster could accuse anybody of anything and thereby establish probable cause. That obviously would be unreasonable.
Correct.
So that's why after Illinois v. Gates and after our Supreme Court recently overruled Jackman, we look at the totality of the circumstances in conjunction with the tip. And here you have someone who's saying there were drugs and guns in this house. The officers pull up into the driveway of what appears to be a rather spacious lot, not any structures that you can see from those photographs that are close to the residence in question, and they smell marijuana. That coupled with the criminal history of the defendant, albeit I see your point, it was quite some time ago, isn't all of that, doesn't that place this case in a different standing than what you're talking about in JL?
Well, again, the deal is JL found not only a lack of probable cause, but a lack even of reasonable suspicion. And so, this case is analogous to JL because they're accusing him of having drugs and guns in his house. But the only thing that I don't see what insider knowledge has been verified, what predictions were made.
But it also says, I'm sorry, if you look at the affidavit in support of the warrant, it's not just like, okay, he has drugs and guns and he's walking down the street. It says possession of numerous vacuum-sealed bags containing marijuana, crack cocaine, numerous firearms, a large amount of cash in a safe in the bedroom. That, to me, sounds like they've been inside the house, and that all of these items are located in the residence along with a large amount of marijuana in a vehicle on the property. That's not, I don't think that's exactly the same as JL. Would you agree with that?
I would still say it is the same as JL because the key point in JL was that you didn't have someone saying he's got a gun and he's about to transport the gun to a buyer at this time, at this location, like you had in Alabama versus White. The point is White would not have been good enough if you had just said she's got drugs in her house, she routinely transports them in her car, and that's it. Instead,
in this case, you have more. In this case, you can't say it's like JL for this reason is when the police show up in an area where they have a right to be. You pull up in the driveway, and they say they detect the smell of marijuana. So you have additional factor than just saying, hey, he's got drugs in his house. They pull up and they start smelling marijuana. So it takes it beyond JL, does it not?
I'm not sure it does, Your Honor, because, again, even if we're to assume that marijuana is relevant for probable cause, that the smell is relevant for probable cause after Green.
But Green just
That
says
would-
It is
in
with
and
the
of itself.
totality of the circumstances.
I was gonna say, even if we're to assume that it is, that would still be, like, if the police can pull up in his driveway and smell something, then any random public person can also do so.
Well, but then but you're compartmentalizing this. They get the tip, they go up to the house, they smell the marijuana. So you don't just have the smell of marijuana, and you don't just have a tip, you've now got two factors. So again, Green talks about the totality of the circumstances, so we have to look at the totality of what the police had. They had this tip with information, and they had the smell of marijuana in the driveway. So it's not just, I guess if they saw what looked like a gun in his belt, then that may, take it to the next level and justify a stop.
I mean, the key issue, and again, we do have to keep in mind, JL didn't even find reasonable suspicion, so that's a lower standard. But the key issue, the distinction that I see between White and JL, and the distinction the court emphasized, was the presence or absence of predictions. And so we could call the vague smell of marijuana in the neighborhood a prediction, but it's a prediction that everyone would smell. You wouldn't have to be an insider to make that prediction.
Except for the fact, that I think Judge Hickson mentioned, is the pictures of this property show it's off by itself. I mean, it's not like in a big complex or something like that where you could have the smell coming from someplace else.
I mean, I could see that argument being made under some circumstances, but I don't agree with it, because there are numerous pictures in this case, but only 2 of them were attached to the warrant, and I included those in my reply brief, and those do not show much in the way of angles at all. They really don't show they don't show at all how close any buildings or houses may be to the left of the house. They really don't show much to the right of the house. They don't show what's on the other side of the road, how close it might be. They don't show anything behind the house. And so I submit that those pictures really do not show that this is some kind of
push back a little bit on that. I mean, I've got the picture right here, and I mean,
It's a big yard.
I grew up in the country. This looks like kind of what it looked like, where there's not much around, and that's a picture from pretty far back, and you can see there's just nothing around it.
You can see it. I don't know if Your Honor can tell in that picture, but that's a tree to the left, so you can't see at all to what's to the left of the house. There could be another house 30 feet away from there.
You can definitely see a lot on the other side.
You can see some on the other side, but anyway, the point is, if we're going to deal with this smell in the air, the police didn't even claim in the affidavit to be able to identify where the source of the smell was. I submit that they don't identify or negate the idea of any other individuals out there smoking marijuana. They don't negate the idea of plants possibly being grown that are marijuana or
They're
hemp
not
somewhere in the area.
Proving the case beyond a reasonable doubt at that point. They're trying to set forth facts to establish probable cause. I'm not sure, do they have to negate every single other possibility?
Well,
in this affidavit?
the doctrine, Your Honor, of plain smell derives from the doctrine of plain feel, and that doctrine comes from Minnesota versus Dickerson. And in Minnesota versus Dickerson, the feel had to make it immediately apparent that the suspect had contraband on him. And so, if we're going
what?
to
Conduct a warrantless search.
conduct a warrantless search.
That's not what we have here. We have a search with a warrant based upon this affidavit. So it's not like the officers smelt this and said to themselves, oh, I have exigent circumstances for whatever reason. I need to bust this door down. No, they put it all in an affidavit, swore to it, and got a warrant.
Right, but ultimately, the immediately apparent to give rise to a warrantless search was to give rise to probable. If you have probable cause, you can search a person warrantlessly. So without the plain smell, without the plain feel, you don't have probable cause. If you don't have probable cause, the judge is not supposed to give you a warrant.
Yeah, but again, we're not talking about officers going to the magistrate with only that fact.
Right.
We can't oscillate the tip. We can't oscillate the criminal history. We can't oscillate the odor. We have to view it in totality. And
Well, If Your Honor is of that opinion, I guess I would still point out the
That's
fact.
not my opinion, that's the Supreme Court. Both of our Supreme Courts have said that. We look at the totality of the circumstances to establish probable cause.
And I agree that is the test, but let's assume that that was enough for probable cause, I guess just having an anonymous tip without any kind of predictions coupled with a smell when you pull into the driveway. We've still got the problem that the anonymous tip in this case didn't say the dates of the crimes that she was alleging, and she didn't say the address of the crimes where she was alleging. And so my position is that the anonymous tip really did not connect the police to this address at all. And that was really probably our biggest argument below, and the judge, denied our argument, but there's simply no.
I don't mean to interrupt, but what was the trial court's ruling on that particular question? Because as I remember the affidavit, it basically said this was the defendant's residence at such and such address. It sounds conclusory. What did the trial court say about that?
I don't believe the trial court addressed it. I know that we specifically just mentioned in our certified question that the tip said he did it at his house but didn't give his address, and I don't believe the trial court meaningfully addressed that topic. But I would submit that arguably could be dispositive even if we sort of lost on everything else. And so seeing that I'm out of time, I guess I'll sort of reserve for rebuttal.
General Coleman?
Good afternoon, Your Honors, and may it please the court. Ronald Coleman on behalf of the state. This court should either dismiss the appeal because the certified question fails to adhere to the strict requirements of Rule 37, or in the alternative, affirm the denial of suppression because the trial court properly determined that the warrant, even with some of the information excised, provided sufficient probable cause of a crime being committed. Even though the defendant seems to have not addressed the requirements of a certified question, unless this court has any specific questions, I'll sort of briefly say that the question really only references the term probable cause. It doesn't establish what that standard is. It doesn't reference a statute. It doesn't reference a constitutional provision. It doesn't really elaborate what that issue is. So the state's position is that does not adhere to the strict requirements of Rule 37. To the extent the defendant in his reply brief says something along the lines of the state is acting nefarious by agreeing below and saying something above and how his due process rights have been violated, that's simply not a meritorious argument. Whether a certified question complies with Rule 37 is a jurisdictional question that this court has to address regardless of what the parties agree to below or above. That's something that this court has to do. So there's no nefariousness going on. There are no due process violations, anything like that.
So is that the state's only argument as to the inadequacy of the certified question, that he doesn't specifically cite the Fourth Amendment?
It doesn't really say what the legal issue is or even the remedy. Our position is that specific prong, I think 37B2, is the one that's not met. But it's broadly what the legal issue is, and specifically has to state what the standard is, what sort of constitutional provision or statutory provision it's relying on, and even what remedy. And instead it's just, did the trial court err by finding that there was still probable cause, without laying out what probable cause is or how that would create a violation or any other remedy. But unless this court has other questions, I'll pivot to the merits of this case, because this court can easily just determine that he loses on the merits. There was probable cause here. And I think it's important to point out what both what you said, Judge Hickson, and what you said, Judge Campbell, is that the defendant is really trying to compartmentalize these different facts that were included in the affidavit, or isolate the facts, as you said, Judge Hickson. And really, when we're looking at whether the warrant provides, or whether the affidavit provides sufficient probable cause to issue a warrant, we have to examine things in the totality of the circumstances. We have to look at all of these facts in conjunction with one another. So the defendant first complains that there's this anonymous tip which says that that the defendant, quote, is in possession of numerous vacuum-sealed bags that contain different drugs, marijuana, crack cocaine, and regular cocaine, including a number of firearms. And it's even so specific to say that there was a large amount of cash in a safe in the bedroom. So we have that tip, and the informant says it's at the defendant's house.
But doesn't identify that house.
Doesn't identify it, but what we can infer from the next fact that is presented is that officers went to this house, that officers understood who this defendant was, that they were familiar with him, that they knew what his address was. So
Is that in the affidavit? It just says they went to his address, right?
it says they went to his address.
Okay. Again, there's nothing that really connects as far as what the anonymous tip is, not mentioning an address, and the police then going to this address. Now, and so it's silent as how they determined it was this person's address.
It is silent. I don't think the affidavit has to have the officer specify that I know the defendant and I know he lives at this address. That's a rational inference when we're looking at, I got an anonymous tip that there are drugs and guns at the defendant's house, and I went to this address. It's a rational inference that you know that that's the defendant's.
Well, now, wait a second. This officer would be asking a judge or a magistrate to sign a court order that you guys can go out there with police cruisers and guns and, if necessary, knock down the door to this private residence. If you're a magistrate or a judge and you're sitting there reading that affidavit before you authorized that action, wouldn't you want to know how the officers knew they were talking about the correct house? I mean, this isn't an academic requirement. You see this in the news all the time where officers end up at the wrong residence and people have died under those circumstances.
Certainly. And
Isn't this an important point?
it is, and certainly the affidavit could have been bolstered even more. Like, there can always be more words added into an affidavit and more facts that would be helpful. But
What facts in this affidavit establish that this address was the defendant's residence?
I think there's an implicit statement by the officer that I know that that's where the defendant lives. I went to this house. They told me, I received an anonymous tip that there were drugs and guns at the defendant's house. I went to this address, which can implicitly be determined as the defendant's house, and I smelled marijuana. And so, again, it would be great if officers, put every single fact down there.
It just says they drove to the residence of 5870 Summitville Road.
Correct.
Doesn't say that was the defendant's residence. We don't know why they went there.
But again, looking at the totality of the circumstances and reading these separate facts together, it's a rational inference that it's pretty clear that the defendant lived there, and no one's really challenging that on appeal. And so,
Well, he is.
Yeah.
he's arguing that the
Well, no one's
affidavit
saying
does,
he
but
doesn't
everyone
live
knows-
there.
Sure.
What we're saying is this adequate for a judge to authorize? It happens all the time, but it really is an extraordinary order when you think about it, that a warrant issues to allow officers to go into someone's home. How do we know that this is his home?
And again, I think it's a rational inference. Again, I agree that it would be better, if it's sort of spelled out in its entirety, if we have the benefit of hindsight and could have instructed this officer to include additional facts. Those are always great, but when we're looking at the question of is there probable cause, and specifically on the issue of is there enough here to say that this is the defendant's address, there just is. The magistrate who signs this.
On what other than conclusory statements that it is in fact his house?
That's all that is needed, Judge. If an officer says, I know the defendant lives at this place, that's a conclusory statement.
But
It
if
would
he
be
says
perfectly
that,
acceptable.
but that's personal knowledge the officer has. Because we've all seen these cases where officers, I know the guy. I'm familiar with him. I know where he lives. And that's come up before. In this case, there's a gap from the anonymous tip to the officer saying, we want to search this particular address. How do they get from A to B? And that's the point I think Judge Hickson's trying to make, is that ordinarily you see some kind of connection, a nexus between the two.
And that's certainly great, but the nexus here is a rational inference, and that's what it has to be, is that officers, based on this tip, went to this specific address. The inference is that is the address that they know the defendant to live at. And then I think that's bolstered by the immediate discovery of the smell of marijuana. They have a tip that the defendant has marijuana at this house. They go to this address where they know an inference allows to say that they know that the defendant lives there. And then as soon as they pull into the driveway, they smell the odor of marijuana. That bridges the gap. And we don't have the Golden Gate Bridge, but we have, a wooden drawbridge. That's just enough to get us to probable cause. And then looking at whether all of these in conjunction establish probable cause. Again, you have this anonymous tip, which does include insider information. State submits it doesn't have to. The defendant's reliance on White and JL those cases focus solely on just the anonymous tip and whether the anonymous tip by itself is enough. But again, we don't look at these in isolation. We don't compartmentalize these facts.
I hate to put you on the spot as to a record citation, but if you can recall, where in the affidavit does the officer swear that I knew this to be the defendant's residence?
I don't think it's explicitly sworn, Judge. I think that instead has to be a rational inference of, this tip told me that the defendant had drugs at his house, and I went to this address. It's reasonable to determine that the officer, I looked it up or knew from personal knowledge beforehand, somehow knew that that was the address that the defendant lived at. And that's, again, it's not, when we're talking to bridging that gap, it's not the Golden Gate Bridge. It would have been much better if the officer specifically said, I've been to this house before, I know the defendant lives there, I've seen him there. All of this additional information would have been phenomenal. But it's not, it doesn't destroy the bridge. It just means that we have a more tangential link, a circumstantial link. But we have that with the fact that I have this tip, they told me at the defendant's house, then I went to this address. It's a reasonable and rational inference that the officer either looked up or knew where the defendant lived and went to that address accordingly.
So I know in this line of work, we've all seen a bunch of affidavits for search warrants, and you probably know the language that we're talking about here that we generally see in these affidavits. That I looked up residential records with the county property office. I saw that this property was in his name. We've conducted surveillance. We saw the defendant recently coming to and from the property, so we know that he lives there. We pulled his trash. We found his old mail in it. Things that establish that this is the correct house. If we ruled in this case that this affidavit was adequate, which basically says I get an anonymous tip that it's at his residence, and I went to this address without anything else, without any further corroboration or basis of how that knowledge came to be, wouldn't we basically be saying to law enforcement, you're wasting your time doing all of this investigation to make sure that you're actually investigating the correct residence? Wouldn't they start omitting that from search warrant affidavits in the future? I
don't think so, because this isn't necessarily a carte blanche approval if this court found that there was probable cause. And in fact, this court can note that this is weak. This made it a much closer call than it needed to be. But there's nothing that would incentivize officers to continue sort of getting close to the line.
But aren't we basically bringing in something outside the four corners of the warrant in order to do that?
No, not beyond rational inferences. The magistrate's allowed to use rational inferences and look at the facts and determine sort of what do they mean when I'm combining all of them together. If I were to say this court can consider the fact that the officer did look this up and so that's outside of the warrant. But when we look at just the facts of why would the officer go to this address if he didn't look it up and find out that that's where the defendant lived? That's a rational inference that can be made.
What if he didn't? What if he just assumed because, hey, I arrested this guy 3 years ago or whatever, and that's where he lived back then, let's go. And you go there and you smell marijuana outside of somebody else's home. And now you have a warrant authorizing officers to go into that home, and it didn't pertain at all to your original tip. Isn't that possible under this affidavit?
I think when we're looking at the question of whether the warrant creates probable cause, we have to understand where that bar is. And to the extent that there might be mistakes, certainly not something that we want to happen. But when we're looking at the language in this particular affidavit, the state's position is that that's enough when we read all of these facts in conjunction, that there was at least probable cause that that's where the defendant lived and that there was probable cause he committed these offenses. Again, when you look at all to the actual offense, we have insider information. We have proof that he's got vacuum sealed bags, different types of drugs, a safe in his house, specifically in the bedroom, corroborated by or in conjunction with officers going to the house, which rational inferences that they know where that.
Now we're really getting outside the four corners. And I know that it was all. It turns out they were probably correct, but that's beside the point. as we're looking at the affidavit. And I know Mr. Justice was talking a lot about the reasonable suspicion standard. And I just think back to the language in that line of cases that it has to be based upon specific and articulable facts.
And we have those here, Judge. Again, to the extent he's relying on White or JL, those were analyzed specifically with just the anonymous tip.
And I'm
Yeah.
really just talking about the address here. How we know we're
Yeah,
at the right
I
house.
think we're all on the same page on
I-
White and JL, but
Then I think the best that I can tell you is that we have this link that allows for an inference, that allows the magistrate judge to do it. Again, it's certainly not the best, and this court can express so in its opinion and say, you're cutting really close to the line, you really need to watch it. And, you know, even caution, we caution people from doing this, but it's enough. It ties the nexus between the tip and the address is, he told me it was at the defendant's house, and then I went to this address, and it's, why would he do that otherwise? And it's a rational inference that the officer knew, that something told him that the defendant lived at this address. I don't want to belabor the point the state submits that this, you know, again, this is certainly not as solid or strong as it could have been, but is enough to breach the low bar of probable cause.
That horse may officially be dead, but thank you for jostling with us.
Thank you, Judge. Unless this court has any other questions about the probable cause of the underlying crime, we submit that when you view all these facts in totality, that they certainly establish probable cause of a crime. And we ask that you either dismiss because it failed to comply with the requirements of Rule 37 or affirm the denial of suppression. Thank you.
thank you.
Thank you.
You've got your 4 minutes left, Mr. Justice.
With regard to that last point about the certified question, I know one thing the state said was that we didn't mention the Fourth Amendment in our certified question, but I would just point out that the Tennessee Supreme Court case of State versus Day didn't mention the Fourth Amendment either, and they seem to think that that was a perfectly good question. They mentioned reasonable suspicion. Here we mentioned probable cause, and further we went into, I submit, a fair amount of more specificity than just the words probable cause. The context also made it perfectly clear that we were trying to suppress the contraband used to convict Mr. Cummings. So I would submit our certified question is clear. With regard to the question of where in the record it identifies or lists any facts for how this is addressed as Mr. Cummings's, the only one I find is on record page 86, where it just says, this being the residence of Mr. Sedrick Darnell Cummings, date of birth 8/16/1980. And that's after listing the address. So it's not actually even a complete sentence, but it definitely doesn't list any facts or explain how the officer knew that. And the state says we're allowed to infer, just sort of assume that the police were doing the right thing and that they were acting reasonably. But the Supreme Court in Aguilar versus Texas specifically talked about how if we were allowed to just infer that the police are always doing the right thing, that they're always acting righteously, they're always acting intelligently, and they're always acting reasonably, if the magistrate could just infer that, then the magistrate would simply be a rubber stamp for the police. And that's what we're trying to prevent here, is to prevent the judiciary from becoming a rubber stamp for doing whatever the police want to do.
Well, you could make your point. I mean, getting back to my hypothetical, the officers here could be acting in completely good faith and saying, yeah, I remember that guy. He lived there 3 years ago. Let's go to his house. And they could just be wrong.
That's true, or they could be acting on some other anonymous tipster who says, you know, hey, do you know where Sedrick Cummings lives? And they go, yeah, he lives on Summitville Road and at that address, but then that person could be wrong or that person could be lying. There's all sorts of ways that they could be wrong. My understanding is the house is not technically owned by him. It was owned by his parents, and so it probably would not have been registered to him. But in any event, they don't list how they knew that information. And in State versus Smotherman, the Tennessee Supreme Court specifically talked about how the presumption of reliability, which is what the state's asking for, but not using those exact words, but what the state wants is a presumption of reliability that the officer just knows what he's talking about because he's an officer. But in State versus Smotherman, the presumption of reliability only applies if the officer explains where his source of information is coming from, and specifically that it's not coming from some unreliable source like a criminal informant. And so I just submit that here we don't have any identification at all of the officer's basis of knowledge. We don't have any presumption of reliability, and therefore we cannot just infer and rubber stamp the reasonableness of the police actions. For those reasons, I would ask that the court accept the certified question and then reverse the denial of the motion to suppress and dismiss the indictment.
Thank you. Thank you both for your good arguments and well-briefed case. And we'll take up the next case, please.